This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and on behalf of Judge Bennett and Judge Golden, we welcome counsel to this oral argument, which is being live streamed for a public viewing as we speak. We will conduct the hearing in the same manner as if we were all in the courtroom together. Each of you has 15 minutes for your argument, and the appellant has reserved some of that for his rebuttal. Unless there are announcements, I'll ask Mr. Hibner to call the case.
David Nichols versus Metropolitan Nashville Airport Authority.
Mr. Freeman, you have the floor.
Thank you, Judge Clement. I want to thank judges here this afternoon for taking the time to hear this case. Judge Clement and Judge Bennett, I have been before you. It's good to see you again. Judge Golden, I'm not sure that I've had the pleasure, but I will say that I have an opening statement and I'll have some comments to make. And of course, you can feel free to interrupt me at any time and ask questions. I'm assuming I will receive a good number of questions here today. So having said that, I'd like to start off by reading again a brief introductory statement about our position. Our position is fairly straightforward. The trial court ruled that Mr. Nichols was merely characterizing his claims as negligence when they actually sounded in civil rights. We take the position that the trial court misinterpreted Mr. Nichols' actions. When Mr. Nichols decided to sue under the theory of negligence, he committed himself to presenting proof that would sustain a claim of negligence. Mr. Nichols made a conscious decision to sue under negligence, and that decision was based on the facts of the incident as he perceived them. He did not believe that the defendant's officers intentionally deprived him of his civil rights, nor that the defendant was deliberately indifferent in failing to train its officers. Mr. Nichols believed that the defendants and its officers were negligent and intended to present proof of that fact. Mr. Nichols did not believe that the facts of this incident justified proof of intentional conduct, which would have been required for his claims to be cognizable under a constitutional standard. This choice was not mere characterization of his claims, as the trial court determined, but rather a deliberate decision by Mr. Nichols that was supported by the proof that Mr. Nichols believed he could offer during the trial. In choosing a negligence claim, Mr. Nichols limited himself to offering proof of negligence only, rather than intentional, unprivileged conduct or deliberate indifference, because negligence claims and civil rights claims are distinct and mutually exclusive. So, Your Honors, that's the position that we took in this case. That's outlined in our brief in detail. And I think it's important that the court understands that there is a big difference between a negligence cause of action and a cause of action arising out of a claim of a civil rights violation.
Mr. Freeman, you make a good point. However, and the trial judge agreed with you initially, but after reading the Cochran versus the town of Jonesboro decision, the trial judge changed course, and the Cochran case seems to be very close on point with your case. So how do we distinguish this from Cochran?
In Cochran, our position is that there was excessive force, and in that case, that's what makes the difference in Cochran and our case, and in fact in the Timmons case. When I argued that the Timmons case applied, that's the case I thought we had here with Mr. Nichols. Because in the Timmons case, we had officers that were using privileged force, well, unprivileged. They had the right in a sense to do what they did, except they did it in a negligent way, which resulted in injuries. And that's what we're claiming here, that when Mr. Nichols and his wife were in the airport and the police officers there came, they escorted them from the baggage claim area all the way. And I don't know how many of you know, I'm sure most of you know the baggage claim area and how the airport is, but they walked them a significant distance from the baggage claim area all the way to our position is by the rental car area on the bottom floor. And it wasn't until they got on the tile or concrete floor right there as near the exit that the officers at that point executed a restraint hold. And our position is that they didn't use excessive force in doing that. They just did it in a negligent manner. The proof would be that my client had a heavy backpack on. And in doing so, when they made that move, they weren't prepared for that heavy backpack. And as a result, he fell to the floor and he severely injured his face. His face hit that concrete and tile floor. So that's the crux of the case. And our position is they had a right to touch him. It wasn't a mishap. It wasn't, they just accidentally fell on him. No, they had a right to do that. But the way in which they did it was negligent. And that's what happened in the Timmons case. So we think Cochran is distinguished.
What gave them the right to touch him?
Well, as I understand it, they believed he was not acting appropriately. I guess when we get into
wouldn't the purpose of them touching him would have been to restrain him?
That's right. And we're not, in our lawsuit, we're not claiming that they used excessive force in doing that. In the sense
was
that
it a lawful restraint or an unlawful restraint that you're claiming?
Right. Well, I'm not sure that we have to make that specific distinction here, because it's a civil case involving an act of negligence in the way in which they executed that maneuver, Your Honor. So,
wouldn't it have been an intentional act?
Well, my colleague and I talked about that, and we kind of characterize it this way. If you go to a doctor or a dentist, they have the right to they're going to put their hands in your mouth, or they're going to operate on you and do something. But when they do so in a way that's negligent or below the standard of care, well, they had every right to touch you. But when they went and did something in a negligent manner, that's where the mistake was made. So this isn't a mishap. A dentist can do a root canal improperly. He'd have every right to be in there doing the procedure. So here, the officer may have had every right, and we're saying he didn't use excessive force. The way in which he tried to secure our client, he did so negligently, like in the Timmons case. So that's the distinction here. And I understand that the Cochran case has come out, hasn't been out that long, but I'm afraid that if we say that this case is akin to Cochran, then are we not saying that anything that a police officer does in the line of duty ends up being a civil rights issue, and that there's no longer a claim against a police officer in the state of Tennessee for negligent conduct? And that's the concern here, is that we've pled our case. Now, I will say this: if we go to trial and there's testimony and evidence that this was an intentional act on the part of the officer, our claim is gone, right? Because we've been unable to establish that it was a negligent action. And I want to point to the one case that I believe the defendant cited, the Morello case, where that was the one case where there was not a civil rights action and a negligent action that was basically paralleling one another. In that particular case, it was just a negligence action, but there was a bench trial, and at that bench trial, court found that there was excessive force. So in that case, that may very well happen here in our case, but we're just asking, give us an opportunity to put on our case, establish whether it was negligence or not, as we have pled. And if it's an excessive force case, then we lose. And the argument there would be, well, it requires litigation. It requires the defendant to go through the process. That's true. But why not? I mean, let the legislature worry about that. Let us have our day in court, if you will, and not dismiss this case at the very outset based on this idea that, well, you're really pursuing this case and not that case. We can't be any clearer. We're pursuing a negligence action in this case, similar to Timmons, and Cochran doesn't apply because in that case, they found excessive force. So thank you.
Thank you, Mr. Freeman. We'll hear from you on rebuttal. Mr. Klein, the floor is yours.
Having me. May it please the court. My name is Kevin Klein. I represent the Metro Nashville Airport Authority. As the court, I think understands, as indicated, this case presents one issue: whether the plaintiff's alleged injuries arise out of civil rights under the GTLA. If so, the airport keeps its immunity, and simply stated, from our perspective, the court should uphold the lower court's determination that the airport is immune, because a claim of inappropriate or excessive use of force to effect a seizure, that's quintessential civil rights. And I think, as the court picked up and as Mr. Freeman has indicated, this isn't a mishap. This was an intentional grab for purposes of effecting a seizure. There are really three components to our argument in this regard. First is the recent decision in Cochran really went through and painstakingly looked at, here are the state cases, here are the federal cases, and here's what it amounts to under Tennessee law, gives us a framework. And under that framework, the plaintiff's claims fit squarely within what the court has defined as civil rights. Now, related to that is the second prong, which is the court, not artful pleading, determines the gravamen of the complaint. Much like in a statute of limitations, the court makes that determination. And then third, something that is noted in a lot of cases, but recently was noted in Morello in applying this exception, is any ambiguity as to whether immunity exists tips in favor of retaining immunity. So against that backdrop, I thought that it might be helpful to talk about the summary of the facts, the procedural posture, because while this is here on a motion to dismiss, there was a little bit more to it. The plaintiff filed an original complaint. We filed a motion to dismiss raising the civil rights exception. The plaintiff then amended. Now, the reason I mention that is that the courts talking about the civil rights exception repeatedly say you can't recharacterize to get around this. You can't circumvent this by taking what's really something and calling it something else. In the first pass, before we raised this defense, the plaintiff alleged that he wasn't confrontational, aggressive. The officers grabbed him, slammed him to the floor, threw him with such extreme force that he went face first to the ground. The allegation was the defendant breached its duty using negligence language, but here's the critical piece, by using excessive force. That's in the first complaint at paragraph 52. Also alleges unlawful restraint, also alleges the officer with intent to harm physically attacked the plaintiff. That's at paragraph 71. So we file our motion to dismiss, say, this is civil rights. This is what the court's talking about in Jackson and so on and so forth. The plaintiff amends the complaint. and reframes it slightly to say an armbar technique was attempted, passive voice, and it resulted in him, Mr. Nichols, falling, hitting his face. The way we see it, that is an attempt, that is what the court is talking about. And we don't even have to speculate here that the plaintiff is characterizing one thing as something else for purposes of getting around this exception. Now, what I'd say is that, as I think Mr. Freeman indicated, there's no real dispute that there were police, they were called for police business, they had an interaction, they put their hands on the plaintiff, and they intended to put their hands on the plaintiff in exercise of their police powers. Now, from our perspective, that triggers, that's civil rights. That's it. That's the accident occurred in that circumstance, which means that we retain immunity. And it's not the case of somebody falls down the stairs and lands on somebody. It's not a case of the officer is driving and is negligent and hits someone. It's a case of intentional touching results in injury in exercise of police power.
So if the intentional touching is done in a negligent way, and yes, he intended to touch him, but he threw him or did some sort of maneuver improperly and therefore injured the person, the negligence doesn't rise above the civil rights or separate itself from the civil rights?
I think that's right. And what it is it's the result of these two different sections of the statute. The first portion of 205 saying immunity is removed for negligence, and then the next part saying except if it arises out of civil rights. So even if there's negligence, if we're talking about application of force by a police officer in the exercise of police powers, that's civil rights. And it doesn't matter if up here there was negligence. And I would also point out that the plaintiff in the most recent version of the complaint, they allege battery. They allege false imprisonment. That's another claim that is alleged. They allege unprivileged use of force by the officer. So the bottom line from our perspective is, and I think Judge Bennett, you hit on it, there's negligence removes immunity. Then there's part B, which says, except if the injury arises out of false imprisonment, one, which is one of the claims here, and then a number of other things landing on civil rights. And that's what we're here talking about is civil rights and what does that mean? And we point to the case of Graham, the Supreme Court case that says any application of force during the context of a seizure or arrest is evaluated under a reasonableness standard for Fourth Amendment purposes. So it doesn't mean that you're intending to cause harm when you're looking at Fourth Amendment, which is, definitely civil rights. It means objectively, did you use more force than is necessary? Even if somebody's trying to put that in the context of duty breach, causation, harm, it's civil rights under the Fourth Amendment, which the Supreme Court says you look at under that standard. And really, Timmons has come up a lot in the briefing here, and really the question I think is, if we did Timmons over again and said you should be immune because of the civil rights exception, how does that case come out? if the case is not argued intent versus negligence, but if the case is argued, this is civil rights, and therefore the government is immune, I think the answer is that it's civil rights and the government is immune. It just, that argument was not presented. That argument was not on appeal in Timmons. And along those lines, it's interesting, the Graham case, the case that sets the standard for excessive force under the Fourth Amendment, like Timmons, involved someone who, a plaintiff who was going into insulin shock. That's Timmons. Officers come on the scene, misread this, think that it's something other than what it is, apply force. That's Timmons. They come upon somebody who's suffering from insulin shock, misread it, do some things. Graham was talking about the Fourth Amendment, civil rights, quintessential civil rights. And so I think that says if the other argument was made in Timmons, that wins. It was just the wrong argument. And for the same reason, this is the same thing, intentional application of force. And if you permit a plaintiff to recharacterize that as duty, breach, causation, harm, you can take any tort and change it into that language. The question, Judge Bennett, do you have a question?
You're very perceptive in saying I was pondering something there, or I'm so obvious. So does this provision in the GTLA regarding immunity for civil rights, does that amount to a blanket prohibition against suing a city or county officer for a civil rights violation?
It prevents, it does under the GTLA. It prevents you from going after the city when there's an alleged civil rights violation or something that preclude or that implicates civil rights. That it just like any of the other exceptions there, it says negligence except.
I know that you can sue a state officer in state court for civil rights violations. It just seems odd to have the prohibition in the GTLA.
And,
so I'm kind of amusing thinking about all this, how it fits together.
Understood. And perhaps it is unusual, but that's what the legislature, that's what they put. And so from Jackson,
they do a lot of unusual things.
Right. And so from Jackson, the case that really set the stage for this was Judge Clement's decision. And that was I think the first time the Tennessee Appellate Court said, we haven't really dug into this, but the federal courts have been talking about this for a while. This is what this means when somebody is making allegations of negligence, but what they really are claiming is use of force in the context of an arrest or some other thing that implicates civil rights. You're immune. The local government is immune. And there's been a long line of cases following that in all sorts of contexts that I think result in the airport's immune. And to say, well, let's just have a trial, I think that would defeat the purpose of immunity. Part of the purpose of immunity is to not encumber government agents when they shouldn't. And so here, just to sort of sum up, we want that to not happen because on the face of the complaint, this is civil rights, and we appreciate Mr. Freeman's done a great job, but the courts are uniform in saying that you can't take something. I think it was Abraham Lincoln said you can call a calf's tail a leg, but it's still a tail. And here the allegations are civil rights and simply saying we're not trying to pursue civil rights. We're trying to pursue negligence. That's what every plaintiff does when faced with this. That's what every plaintiff does, and if you allow it to pop out here, that's what every plaintiff will continue to do. I've got 45 seconds. If any other questions, I'm happy to take, or I'll wrap up. In short, we think that the court should uphold this decision. It's the right decision. The court, as you noted, initially came to a different conclusion, then said, Cochran pretty much tells me what I have to do here. And the lower court got it right. And I would conclude with one thing that I may have already mentioned, but there may be a thin line sometimes between negligence and intentional tort. This is different. This is civil rights. Insofar as there's any ambiguity, it's got to be resolved in favor of immunity. And for that reason, we ask that the court uphold this. Thank you.
Thank you, Mr. Klein. Mr. Freeman, rebuttal.
Well, I'm glad I saved 5 minutes because I've got a lot to respond to. Every plaintiff isn't going to attempt to do what we're doing. The vast majority of cases took the position that they were taking parallel tracks. Go to one court, don't get the result you want, then you come back and you try a different result. That's not what we did here. We asked that you look at the amended complaint that's in the record that the trial court considered. That's the operative document that needs to be considered, and we made negligent claims in that case. I want to address the points that Mr. Klein made. He mentioned battery and false imprisonment. If you look at our brief, under Limbaugh, we're allowed to do that if negligence is a predicate to that. So I think that's a non-issue as far as I'm concerned in this case. What the issue here is when we look at the statute, GTLA, it's important to note that, and when we look at the statute, I think we can often say that these intentional tort exceptions, we consider those, that's what we call those. That's the kind of the intentional tort exception. Well, guess what? The civil rights, those two words, civil rights, are at the very end of what we consider to be the intentional torts exception. So our position is that includes intentional torts related to civil rights, not negligent actions. If that's what the legislature sought to do, they would have done that. And so in this particular case, we believe we've made out a case for negligence, and we want to pursue that. And as Judge Bennett mentioned, if you say right now, if you say that Cochran applies, then you're basically saying that you cannot bring a negligence action against a police officer in their official capacity. There's not a situation that would allow that, because in every instance, the defendant could say, well, that's civil rights. That's involving use of force. And we say that that's going too far in this case to do that. Now, the Jackson case was mentioned, and as I understand it, there was a reference in that case to excessive use of force and violation of constitutional rights. We're not claiming that in this case. But having said that, if we get through the trial process and it's found that we cannot prove our negligence claims, then of course it ends there. But we didn't take two tracks here. We didn't go down one path and then back up and try to go down this path here. We were specific in the direction we wanted to take, and that really hasn't changed at all. And so again,
there could be situations though where there could be negligence on the part of an officer. For instance, if you were involved in an automobile accident, or if there was an emergency, for instance, at the airport, and the officer negligently was trying to assist but didn't assist properly, didn't provide oxygen, or didn't provide other assistance in an appropriate way, that would be negligence. It seems like it's a situation like, unfortunately, your situation perhaps, where someone's exercising police power and that's maybe that's the line that's crossed here.
Right, and I think in our brief, we asked that if that's in fact the case, then maybe clarify Cochran in that regard. But it doesn't really address the Timmons case where there was if we're going to say that if someone is using their police power as a police officer and they are negligent, what cause of action do you bring? Do you bring a civil rights action, a 1983 action? Well, if that's the case, the burden in order to establish a 1983 cause of action is unprivileged use of force, and claiming negligence won't get you relief. So I understand, Judge Golden, your position, but if you can ever envision a situation where there's no, well, I've run out of time. I apologize.
Thank you for your answer.
Okay, thank you.
Thank you, Mr. Freeman and Mr. Klein. You've both done an excellent job of putting a very subtle and important legal issue in our lap. We will do the best we can. Mr.